Welcome and thank you for attending today. We are very pleased to have as our speaker today Hugh Kane. Hugh is a shareholder with Hopkins and Hebner, PC. He's a graduate of the University of Washington School of Law. He's practiced in state and federal courts of Iowa since 1983 and primarily works in employment and local government law. Hugh has advised and litigated cases for Iowa private employers and local governments on a wide variety of employment, civil rights, safety, and wage issues. He has negotiated collective bargaining agreements and assisted local government boards with governance, open meetings, and open records issue. Hugh is a former chair of the Iowa Bar Association's Employment Law and of the Government Practice section. Hugh has substantial experience representing Iowa municipalities in court and other settings. He counsels clients and litigates on land use, city and state code, state and federal law, and taking claims. Also, everybody write down this number. This is your activity ID number for today. It is 240571. Now join me in welcoming Hugh Kane.
Thank you. I'm Hugh Kane, and I want to visit with you today about how to set up your employment manual for a municipality. But before I do, there are two things that you should be thinking about when you're dealing with a handbook. First of all is remember that since it's a government entity, you have to deal with what one of my partners calls that pesky little document, the United States Constitution. So you always have to worry about, are there due process issues, are there equal protection issues, are there various and sundry search and seizure issues that could come up that could bite you in an unpredicted way. So always keep in mind you have to deal with the United States Constitution. Secondly, you need to remember the reality of most Iowa municipalities is that most Iowa municipalities don't have professional human resource folks. Certainly once you get into a big city, bigger county, there may be folks that do that. But otherwise, you are dealing with the governing body itself may well be the employer that is enforcing employment policies. So when you're dealing with that, one of the things I always try to keep in mind is that I want to make sure that my handbook is fairly simple and fairly short. Because if it's complicated and long, the folks who are running the municipality either aren't going to have the time or the inclination to know all of the policies and procedures that are now contained in the handbook. So it's very important to keep it simple, keep it short. I sometimes am asked to look at a handbook for a municipality that may be 30 to 50 pages long. From my standpoint, that's a non-starter because most of those policies won't be followed, or they'll only be followed more likely in the breach than any particular honor. So with those two caveats, and let's talk about some things that you should consider when you are setting up your handbook. First question is, who's covered by the handbook? If you are asked to put together a handbook for a county by the Board of Supervisors, then who does the Board of Supervisors govern? Or if you're asked to put together a handbook for a city, who does the City Council, who does the Mayor control? And those are really important issues that you have to think about. There's an Iowa case from the Supreme Court early part of the 2000s that's called Warren County Board of Health versus Warren County. And in that case, the Board of Health decided that they wanted to pay their secretary a lot more than everybody else in the county got paid. They also decided at some point they wanted to fire their executive director. In both cases, the County Board of Supervisors steps in and says, no, you cannot pay your secretary more than any other secretary working in county government gets paid. And by the way, we really love the guy who's the executive director, so we won't let you fire him. That dispute eventually winds its way to the Iowa Supreme Court. And the Iowa Supreme Court says, look, you have to know which governmental entity has control over which employees. Under the statute that sets up the Board of Health, the Board of Health is allowed to hire and fire, or excuse me, allowed to hire its employees. The Supreme Court says that the power to hire implies the power to fire, so that only the Board of Health can hire and fire its own employees. And it looks to the issue as to who can pay. It looks at, the Supreme Court looked at the payment plan that the county had put together, and there wasn't any binding provision that says that the Board of Supervisors have the authority to enforce the pay plan. So somebody could violate it with impunity. So what does that tell you? It tells you that when you are dealing with a county, which employees actually report to the Board of Supervisors? It's relatively very few. The 331 is the statute that governs counties. It's the home rule statute for counties. That statute in the 900 section gives the individual office holders, that is the treasurer, the recorder, the auditor, the county attorney, and the sheriff, all have their own independent authority to hire and fire their employees. So the result is, if a Board of Supervisors says, we're going to put together a county-wide handbook, technically none of those employees are going to be subject to it unless it's adopted. Board of Health would be the same issue. The assessor also would have independent authority that comes from the conference board as opposed to the Board of Supervisors. In city government, you have the same problem that arises with library employees. Library employees don't report to the city council or their administration, or their administrative managers. They report to the library board. So you've got this problem as to who's going to be covered by the handbook. If you put together a handbook that's supposed to be either county or city-wide, you have to use your negotiating skills. That is, you've got to get a buy-in by the independent boards or the independent elected officials to that handbook. In the case that was up a minute ago, the Warren County Board of Health case, what that handbook did is on the cover of the handbook, there was a signature line for each independent governmental official that is independently elected, or an independently appointed board where they signed off on the handbook. So if you're going to try to put together a handbook that's going to be citywide or countywide, make sure that you get an effective buy-in from the other officials. Where that can be, one trick that you can use when you're trying to negotiate that is you can point out to those independent officials that they can be, under the Iowa Civil Rights Law, they can be individually sued for violations of civil rights laws. So that's an important reason why you should be signing off on the handbook where there are provisions dealing with civil rights. Now, the counter argument, of course, to that is that under 670, any county, city, local government official is indemnified by the governing body except for punitive damages. And there are no punitive damages under the Iowa Civil Rights Act, but you don't necessarily have to point that out to the people you're negotiating with. So those are some things to keep in mind as to who's going to be covered by the handbook. The other important issue regarding who's covered is what about your unionized employees? If you've got unionized employees, their Bible is the collective bargaining agreement. But oftentimes in a collective bargaining agreement, there isn't language similar to what you would want to put in a in a handbook, such as how do I comply with civil rights laws? How do I deal with FMLA? How do I deal with other sorts of things? So one of the things that I often put in my handbooks is somewhere there is a provision that will say that this handbook will govern those issues which are not dealt with, covered by a collective bargaining agreement. Whether that's effective or not depends on how PERB might eventually rule on it. But I think that's at least a good idea to try to set some standards for all employees. The other sort of preliminary issue that you get into in regards to handbooks is open meetings issues. And if you follow municipal law, you know that in the last few months, there was sort of a sea change case that came down from the Iowa Supreme Court, and that's Hutchison versus Shull. And again, it's a Warren County case. And in that instance, there's a 3-person board of supervisors. When you have 3 members of the Board of Supervisors, anytime 2 of them gets together, you have a quorum, and then you potentially have a meeting. In a county that has a 5-member Board of Supervisors, or in a city that has 5 members of its city council, you may not have the exact same problems, but they still can arise. And what happened in Hutchison versus Shull is that the supervisors came up with this scheme to eliminate a large number of employees. And instead of visiting supervisor to supervisor in what appeared to be an actual meeting, they used a third party, the person that they called their county administrator. And she would go from supervisor to supervisor in what I believe the district court and the Supreme Court described as deliberations. That is, that they were negotiating and figuring out how to do this, these job eliminations without it ever becoming public. And then eventually at a meeting one day, they simply announced that a number of folks are no longer employed. They bring suit under the open records law, or open meetings law, and eventually that winds its way to the Iowa Supreme Court, where the Iowa Supreme Court says that type of meeting with an agent is not permissible under the Iowa open meetings law. But you can have that same issue happen in a small county, a small municipality, anytime you're dealing with employment-related issues. Because in those counties that don't have a professional administrator or an HR professional, it may well be the board itself or the governing body itself that is making all the day-to-day employment decisions. And remember what both the home rule for counties and for cities says. It says that a board can only act through a resolution, an ordinance, an amendment, or motion. And all of those things have to be done in open meetings. So the result is, when you're making employment decisions and you don't have professional HR help, you have to, your board members have to be extremely wary that they aren't violating open meetings law and that they're not running afoul of the agency principles that are set forth in Hutchison. Now, the other problem that can come up is that anytime that an employee wants to talk to a governing body regarding his or her employment, the issue is, can you go into a closed session to talk about that? And there is a provision in the open records, open meetings, that does allow, when you are discussing personnel matters, remember, it is only the employee, him or herself, who can ask to go into closed session. It is not the board on its own that can move into closed session. It has to be the request of the individual employee. But the other thing, I guess, at least I call to your attention, is that portion of the open meetings record, open meetings law that is found at 21.9. 21.9 has never been interpreted by any reported case, at least one that I can find. It basically says that when you're dealing with, quote, non-collective or employees who do not have a collective bargaining agreement, you can then discuss matters that are found in the collective bargaining statute, which is Chapter 20, dealing with wages, conditions of employment, including such things as reduction in staff, and that those discussions are not subject to Chapter 21, open records. I call it to your attention. Whether the statute means what it says, I don't know, but at least it's something that you should at least consider when you are dealing with a county that has non-union or a city that has non-unionized employees, and you're trying to figure out what to do on certain issues. That then takes us to a couple of other issues that can bite you on the bottom regarding open records law. Is that there's an Iowa Supreme Court case that says sick leave and who uses sick leave can be subject to an open records request, and you can find out the names of employees who have taken sick leave. You cannot, however, find out, and you can find out how much sick leave they've used, but you cannot find out why they took sick leave. That is, the underlying condition isn't subject to disclosure in open records. Another issue that comes up with in open records is salary and wages. I also do a lot of handbooks and employment work for private employers. Private employers are subject to the National Labor Relations Act. And the National Labor Relations Act says that employees can always talk about terms and conditions of employment, which means they can talk about their wages. That is honored far more in the breach than in actually being honored. I can tell you I look at lots of handbooks where there's language in private employment that says that your salary is confidential, and if you have any questions, you should visit only with your manager. All of that is likely a violation of the National Labor Relations Act. But remember, in public employment, the National Labor Relations Act does not apply. So whatever the NLRB says in its wisdom in Washington technically does not apply to municipalities here in Iowa. But where that comes in is, under Iowa law, it specifically says in the open records statute that wages and salary are not confidential. So everybody, if they so choose, can ask your municipality how much Bob and Sarah and Molly make, and it's open records. So one of the things that I sometimes do, because employees otherwise think, oh, how much I make is confidential and no one should know, I will put in a provision somewhere reminding employees that their wages and benefits are public records, and that the public can ask, and we would have to provide that information to them. That takes us probably to one of the more important sections that you need to think about whenever you're doing a handbook. And that is what I'm going to call the EEO sections. Every handbook, front and center, and I oftentimes put my EEO section as my first or my second page, and specifically spell out every category under Iowa and federal law that's protected, and make sure that you include both gender identity and sexual orientation. Those were added in about 2010, and they are often left out of many handbooks that I review. So I'd make sure I put all of that in so employees know from the very beginning that there's no discrimination based on any of the classes protected by Iowa and federal law. The next thing is that you should have a provision that says that sexual and other illegal harassment is prohibited in the workplace. And the EEOC years and years ago defined sexual harassment. It's about a paragraph long. It might even have a couple of bullet points. I throw that in verbatim to most of my harassment sections. And the reason you want to make sure that you cover not just sexual harassment, but other illegal types of harassment is because if you get racial harassment or disability-related harassment, you still want to have a procedure by which an employee can complain. So always make sure that you don't limit your harassment section merely to sexual harassment. Make it to all of the other prohibited types of harassment based on a protected category. Now, why is all of that important? Well, you probably know without me telling you, is that there are two seminal cases from the United States Supreme Court. They're the Farragher and Ellerith cases back from 1998. And again, it was one of those sea change moments. There's a lot of nuance to Farragher and Ellerith. But generally what they provide is that an employer has an affirmative defense to a harassment case if a couple of things happen. So how do you go about taking advantage of that in your handbook? Number one, you need, what Farragher and Ellerith says is you've got an affirmative defense if the employer used reasonable care to prevent and promptly correct any sexually harassing behavior, and remember it's an and, not an or, and the employee unreasonably failed to take advantage of any preventative opportunities provided by the employer to otherwise avoid the harm. Now remember, it's an affirmative defense. Affirmative defenses mean that the burden is on the employer to establish. So how do you go about taking advantage of Farragher and Ellerith? First of all, you have a policy against harassment, not just sexual harassment, but all sorts of illegal harassment. In a perfect world, you would also be training your employees on what harassment is. And in a perfect world, you'd be doing that every year. And in that same perfect world, you would have either an electronic or a paper attendance sheet showing that they went through, your employees went through all of that training on a regular basis. But most of my clients, and including me, do not live in a perfect world. So what can you do? At a minimum, you should have an acknowledgement form for your handbook. And we'll talk about that a little bit later, but the acknowledgement form would say, I've received a copy of my handbook, I understand it, I've had an opportunity to ask questions. I go farther. I put in, I understand my cities, my counties, my employers' policy regarding sexual harassment and other harassment, and I agree to follow that policy. At that point, you now may be able to fall into taking advantage of the first part of Farragher and Ellerith. That is, you as an employer have taken reasonable care to prevent sexual harassment by telling people not to do it, and you've provided a basis to correct it. That is, they can come forward with a complaint. So what's the next provision in your Farragher and Ellerith harassment policy? You put in the complaint procedure. That is, if I believe that I have been illegally harassed, I will report to X. And when you give the person to report to, remember to have two ways to complain. The reason is because if you give a single route to complain and that person is the harasser, then you're not going to be able to take advantage of Farragher and Ellerith because you don't have a reasonable system. So have two ways to complain, whether it's the mayor, whether it's the board chair of the Board of Supervisors, whether it's X, Y, and Z, choose X, Y, and Z and name either them by name or by position as to where you go for a complaint. And finally, you add a sentence in your harassment policy that says, any harassment claim will be promptly investigated. And make sure then you do the prompt investigation. Now, prompt investigation doesn't mean that you go out and hire either an HR professional or an outside lawyer to do the investigation. It can be done internally. Depends upon the resources available to the employer, depends upon the severity of the allegation, but those can be investigated in-house. And an in-house investigation should at least talk to the complainant, get the names of all the witnesses, talk to the witnesses, talk to the alleged harasser. Then you follow back up with the complainant after you've interviewed everyone to see whether what the reaction is, what a response to various and sundry facts that come out. That's how you take advantage of Farragher and Allereth. You make sure that you've got a policy. You make sure that the policy is well known within the organization. You have a way to complain, and you have an investigation route to solve the problem. So those are what you want to make sure that you include in your EEO, your harassment, your Farragher and Allereth portions of your handbook. In addition, as you probably all know, there are whistleblower provisions that apply to public employees. And that's found at Iowa Code Section 70A.29. I have started to put into my handbooks some language that mirrors the whistleblowing statute, which basically says something. If you believe that there has been improper spending, improper action, and if you reasonably believe that this is improper, then complain to X. And again, I'd probably have two routes for complaining so that there's no question that the complaint doesn't have to go to the person who is allegedly improperly spending money or abusing power. Whether it's, I can't tell you that I've gotten out of any lawsuits on it, but it certainly makes it arguable that the employer took those types of claims seriously and proactively tried to eliminate problems concerning them. Let's see. That then just takes you back to any time that you can do an EEO refresher, I urge you to do it. If you ever take a look at the questionnaires that our friends at the Iowa Civil Rights Commission ask, some of the standard questions they ask you, once a complaint or a charge has been made and they send you the questionnaire to answer, is they will ask you what training you have given your employees regarding harassment or EEO issues. They will ask you what training you gave your supervisors. And it may be that the only training they ever got was when they got the handbook and you provide them with the acknowledgement that it was received. But it is so much easier and so much better if you can show there's periodic training. And by the way, there are lots of internet programs on government websites where this could be done. So you don't necessarily have to bring in a speaker. You could simply have somebody do it online, but make sure that you somehow capture when they did the training and what it was. That takes us, I guess, to the next portion of a handbook, which is at-will employment. And when I started practicing law 30-some years ago, everybody was at will unless you were covered by a collective bargaining agreement. Now I tell my clients there are so many holes in the at-will system that you can drive Mack trucks through them. But nevertheless, employers always believe that that Iowa is an at-will state, and then they mix it up with right to work. So those are things you have to deal with. I always put early on in my handbook that you are an at-will employee. And it may be that that's just wishful thinking on my behalf. Because remember, there are lots of reasons you would not be an at-will employee. The first of them is that case that came down, geez, now almost 25 years ago, where Springer versus Weeks and Leo, where the Iowa Supreme Court recognized that you can have a wrongful termination claim as an at-will employee if your employer violated public policy as part of the termination. So public policy is an ever-growing area. It started out by claims that people were fired for filing workers' compensation claims or threatening to file workers' compensation claims. It's morphed into all sorts of things. So if I ask for information regarding insurance and my employer doesn't give it to me and I keep asking and he fires me, that's a violation of public policy. There are public policies that are either going to be found in either the Iowa Constitution and Iowa statutory law, or the Court of Appeals has recognized that federal law can provide a basis for a public policy. So always when you're thinking about firing somebody, click through, is the firing related to some sort of public policy? Are they a whistleblower? Have they reported wrongdoing? Have they called OSHA? Have they done any of those sorts of things? Have they filed work comp claims? Did they get hurt recently in the workforce? So always think about those when you're thinking about firing people. There are also employees who are no longer at will because the legislature says they are not at will. One of the biggest groups, and one of the groups that is consistently ignored by employers is folks who have veterans preference. Veterans preference has been around since I think the late 19th century. It is one of the Grand Army of the Republic, which were the veterans of the Civil War. It was one of their lobbying efforts to obtain veterans preference. And veterans preference applies not just in the hiring of employees, but it applies in the firing of employees. And if you don't know whether somebody is a veteran and you fire them, you've got problems. A veteran that's protected under veterans preference includes all of the wars where there aren't people in the workforce anymore. So World War II, Korea, increasingly Vietnam. But it also includes those small little engagements during the Reagan administration, such as Panama, Grenada, and I think a few others. And then it captures everybody from Gulf War I under Bush, the first Bush administration, forward. So literally, anyone who has been in the military since about 1990 is protected as a veteran with veteran preference rights. And remember, you don't have to be in combat. You only had to be in the military. So if you are a veteran, you are protected from firings unless it's incompetence or misconduct. And those are defined and specifically defined by Iowa case law. So those aren't necessarily easy things to prove. And if you are a veteran, you can subject to veterans preference, you can only be removed after notice and after hearing, so that you are entitled to a pre-termination hearing before the termination. And the hearing is in front of the governing body that appointed that veteran. So you've got to make sure that you know who your veterans are in your workplace. The statute says that you're supposed to be using a job application put out by the state of Iowa that includes that question, are you a veteran and when? But in small town Iowa, that oftentimes is not used. So you've got to make sure that your employment records tell you whether a particular employee is a veteran entitled to veterans preference. I include in my small employer handbooks a request to self-identify as a veteran. So I put that in because otherwise if you fire somebody and they are a veteran, it's a violation of Section 1983 of the federal civil rights laws, and then you get a damage award in state or federal court for compensatory, punitive, attorney's fees. It can be a real unpleasant experience. Other thing to keep in mind is that your civil service employees, if you're big enough, which I think is 8,000 under the 1980 census, are generally not going to be at-will employees because they can only be fired for either for just cause or for specific reasons under the statutes, the deputies, sheriff deputies, and then the city civil service. And remember that most unionized employees can only be fired for cause. But you should check your contracts. I can tell you I have seen at least one contract in Iowa where public employees did not have protection from firing under their contract. That was a group of county attorney or assistant county attorneys, but my suspicion is with a weak union there may be others. Remember when your employer is telling, or when your people are telling you, well, Iowa's a right to work state, and what they're really talking about is they're at will. They're different. Right to work refers to the right to choose or not to choose to join a union. Also remember that when you fire even an at-will employee for a reason that violates a liberty interest under the due process in the 14th Amendment, you've got to give a pre-termination hearing. And so what's a liberty interest? Liberty interest is when I accuse somebody of something that will harm their reputation. So if it's defamatory, the general one, the big ones are you accuse somebody of stealing, you accuse somebody of lying, then you should probably be giving a pre-termination hearing before you terminate. That takes us then to the Family Medical Leave Act. Under the Family Medical Leave Act, every public employer is a covered employer under the statute, which means that the local county sanitary district with 2 employees is technically a covered employer under the FMLA, just like Principal here in Des Moines is, or just like any John Deere or any other huge employer. Technically, they're both covered employers. The difference is there are likely not to be any eligible employees. To be an eligible employee under the FMLA, you have to have 50 or more employees located within 75 miles of one another. And that employee had to have worked for at least 12 months. They don't have to be consecutive, by the way, but 12 months. And they had to work 1,250 hours last year. So the vast majority of small Iowa cities and the vast majority of other sundry municipalities aren't covered because, or excuse me, don't have any eligible employees. What the federal regulations say is that if you are a covered employee, or excuse me, if you're a covered employer with eligible employees, your handbook is supposed to have the actual FMLA notice that's available on the Department of Labor's website. That's supposed to be a part of your handbook. Where I put it is it's like the final page of a handbook. And by the way, the United States Department of Labor website is www.dol.gov. It is one of the best government websites, in fact, one of the best websites and most helpful ones that I know of. So if you're looking for the form, it's there, and there's also answers to all sorts of issues, both from an employee and an employer standpoint at the DOL website. Every covered employer, even if they don't have eligible employees, is supposed to have a poster that's up that shows what the FMLA rules are. And again, you can get the poster off a website, and in fact, they also sell those posters at most office supply stores. So make sure you have the poster up, because technically I think it's a $100 a day fine if you don't have a poster up. So even if you don't have any eligible employees, make sure you have your FMLA poster up. What I do in my handbooks for government employers is I always, even if I don't have any eligible employees, I put in a paragraph that says that the employer is, or the city, the county, the 2080 agreement is a covered employer under the Family Medical Leave Act. But then I say, but we currently do not have any employees eligible to take Family Medical Leave Act. And it's there in case the government ever decides that everybody has to refer to the FMLA even if you don't have eligible employees. And it also answers questions that employees have, because employees will oftentimes be asking their employer about, geez, can't I take 12 weeks leave for because my wife is ill, or I need surgery, or I'm going to have a baby. All of those are reasons you can take FMLA. You cut it short if you put in a provision in your handbook that says we don't have any eligible employees. That takes us to pregnancy. Most small Iowa employers, or at least many of the ones that I deal with, don't have pregnancy policies. They don't have paid leave. They may not have any leave at all. So if that's the case, then you need to put in your handbook what the rule is. And the Iowa law gives you what the rule is. It's found at Iowa Code 216.6, which is in the Civil Rights statute dealing with employment discrimination. And what the Iowa legislature says is that you have to provide either 8 weeks of unpaid leave or leave for the, quote, period of disability, unquote, whichever is shorter. So generally your policy is going to be 8 weeks unpaid leave. And make sure it's right there in your handbook, and make sure that people know that. You should be careful regarding whether you refer to pregnancy leave or maternity leave. Pregnancy leave is what the Iowa Civil Rights Act deals with, and it's tied to disability. If you use phrases like maternity leave can be tied to something broader than just pregnancy disability. It could be tied to that a mother bonding with the new baby. If you do something like that, then you need to be very careful, because at that point, if you are tying the disability not to or you're tying the leave not to disability, but you're tying it to child bonding, then you're going to have to address the issue of paternity leave, because if you're granting maternity leave for baby bonding time to mom, you are likely facing a sex discrimination claim if you fail to do the same thing for dad. So all of the handbooks I write, I always refer to pregnancy discrimination, or excuse me, pregnancy leave. I don't refer to maternity because I don't want to get into that issue as to who are men entitled to disability or entitled to paternity leave. Another issue that you should always cover in your handbook deals with the Fair Labor Standards Act, which is the FLSA. I get asked to do a lot of talking to business groups about wage and hour law. And I gave up long ago asking people to raise their hand in private business if they used comp time. But I was at somebody else's seminar recently where the speaker asked all the private businesses to raise their hand if they were allowing comp time as opposed to paid overtime. And about a third of the hands went up. The good news for municipalities is the only entities in America that are entitled to use comp time are state and local governments, and then the feds get to use it through regulations. It is not permissible to use comp time in private employment. It is not permissible. You have to pay cash overtime as opposed to giving an hour and a half time off for all hours worked over 40. There are, however, limits in municipal law, which is the FLSA says that an employee working for a city or a state, including county, local governments, can only accumulate either 240 hours, or if they are either a public safety, a seasonal worker, or emergency response worker, so your police, your fire, your EMTs, and maybe your your snowplow guys, they can accumulate 480. But either after you've maxed out at 240 or 480, you have to pay cash overtime. I always put in my handbooks that we pay overtime via comp time, and so it's an hour and a half for every hour over 40. I put in that there are limits, and I say who the limits are to, and that after you've reached the limit, you will be paid cash overtime. I think that's important to make sure it's in the handbook so employees know not to expect that they're going to get paid cash time and a half. Now, a collective bargaining agreement, of course, trumps this. So in your collective bargaining agreement, if you agree to pay cash overtime, then you can't use comp time. I would also always include that overtime may only be worked with the permission of the employee's his or her supervisor. And if I were really worried because I got a problem, I might even say that they can only work overtime with the written permission of a supervisor. Because remember, you will get into a problem under the Portal to Portal Act, which says that if you suffer an employee to work, they are working for you, and that is paid time. So how do I prevent suffering an employee from working for me? When 5 o'clock comes, if they haven't gone home, they have to have written permission to continue to work. And by the way, that may become a disciplinary issue, because remember, if your people are working overtime and you have a policy against it, you have to pay them their overtime, but it certainly can be a discipline issue. That is, you're not following the rules. Drug testing. Remember, under the Iowa drug testing statute, which is 730.5, by its very terms, it doesn't apply to a public employer. It says it applies to private employers. The reason is because you have constitutional problems with search and seizure under the Fourth Amendment. So are there some occasions when you can do drug testing for a municipal employee? Well, if they aren't your employee yet, you can do a pre-employment drug test. But you got to make sure that they don't start work and then go for the test. They have to take the test before they become an employee. All of your drivers who hold CDL, so anybody that's over, I think a truck is like 20, I think it's 24,000, but I could be wrong. But it is a fairly large truck, or your bus drivers. Those folks have to have a CDL. And under the federal regulations, which trump Iowa law, you can always do drug testing for them. There are also a couple of U.S. Supreme Court cases from the late 1980s that do allow for drug testing under certain circumstances. I can tell you I never recommend to any of my clients that they do that sort of drug testing. It's It's just, I always tell my clients, do they want to be the test case? And I never want to be the test case. So I would stay away from doing drug testing unless it's either pre-employment or CDL. I would probably put a provision in my handbook that reminds employees that if they hold a CDL, that they are subject to periodic drug testing. An acknowledgement page. An acknowledgement page, from my standpoint, is critical. Because remember, it goes back to the Farragher and Ellerith requirements that I have a known policy that employees know how to complain. So if the only place I put my complaint policy is in my handbook, this is my one and only chance to get them to acknowledge that they have received it. So every employee should have a signed either electronic or a paper copy of the handbook. And if you reissue the handbook on a periodic basis, each time there's a new handbook, they sign for it. I also put into my acknowledgement, in addition to things that say, I acknowledge receipt of the handbook, I agree to read it and follow it. I'll put in, I acknowledge that I'm an employee at will and can be terminated for at any time for any reason. I also put in that I understand the harassment policy and I agree to follow it. And I've started to put in with some employers that I also understand that to work overtime, I have to have approval. And that's where I've got a client who's got particular problems with overtime. Another thing you ought to at least give some thought to is weapons and violence. Under Iowa law, cities, well actually only the state of Iowa can determine who can regulate firearms. So cities, the city of Des Moines, city of Cedar Rapids, they can't have a handgun licensing requirement. But every municipality is also, or almost every municipality I know, is a landlord. And as a landlord, you have certain rights. And one of the things that you have a right to do as a landlord is to ban the possession of handguns, guns on your premises. There's a court, there's an Iowa Attorney General opinion that says that, and it's cited in the materials. So you should consider whether you want to take advantage of that, as nobody gets to have guns on site, on property. I personally think it's a good idea. You're going to have to have an exception for your law enforcement folks in all likelihood. I also include a provision in almost every handbook I write that nonviolence is an essential job function of every position in the city or the county, and that a violation of the nonviolence policy will lead to discipline up to and including termination. I put that in. I also normally put in a civility provision, which says that an essential job function of every position in the city or the county is being civil, not only to your co-employees, but to the public. And again, it's a disciplinary issue that can lead up to and including termination. That takes me through most of my, or all of my slides, but there's a couple other things I tell you about. Make sure that in your EEO section, there's something called GINA, which is the Genetic Information Non-Discrimination Act. That's why you no longer ever get asked about family history of a heart attack or family history for diabetes or any of those sorts of things on a on documents for an employer. I always throw in my employment, my EEO section, that we don't discriminate on the basis of GINA. Let's see, I would also make sure that I have a provision that outlaws the use of alcohol and alcohol and illegal drugs on company or on city property or county property, including vehicles. And then if you're going to have a grievance procedure, you ought to at least have thought that through. That is, are you going to have a progressive discipline policy? Progressive discipline normally starts out as oral warning, written warning, suspension, and then finally termination. If you're going to do something like that, make sure you give yourself an out. That is, you can always stop. you can start the process at any place. So that basically is my presentation, and we'll see if there are any questions.